so many research assistants and students, namely, who are interested in our today's Law After Lunch session. I'm very happy to welcome among us Ross Buckley and his daughter, of course, as well. They came over from Australia all the way, not only to lecture at Halle, but also to lecture here. We're very happy and grateful for having you here on this very fascinating topic, a global sovereign bankruptcy treaty, an idea whose time has now come. The background of all of this will, of course, be explained by Ross Buckley in a minute. Maybe just to give a very short introduction on the German side of the entire story. As you might know, we still have a couple hundred ongoing litigations before German courts with regard to hold out creditors from Argentina, from the Argentina crisis, and the same is happening in Italy. These proceedings are successful. Argentina, being the respondent, has hardly anything to put against them because the Argentinian bonds didn't have a collective action clause, and thus those creditors who didn't agree on a restructuring still have their full title. However, there is movement going on with regard to what we will also learn, UNCTAD principles on responsible sovereign lending. We just had a recent court decision of a German lower court allowing for appeal to the federal court in civil matters, Zulassung der Revision. So we will see in a short future further ruling of the federal Supreme Court in civil matters on this issue. That is not yet a breakthrough, but it is a little step towards convincing domestic courts to think a bit deeper about the entire issue, deeper than just simply applying the legal title, the bond that is there, and saying you have a right for full claim. To think about the implications it has on a global scale, on human rights issues, on developments like in UNCTAD and in the General Assembly, what we will discuss in a minute. So there's a little movement. I may say that we did have a certain role in this because the movement of the courts is based to a certain extent on the legal expert opinion I wrote. So that's very challenging, interesting developments going on domestically, but also internationally, and that's what we're gonna discuss with Ross Buckley. And we have among us with Ross Buckley the leading expert worldwide on this. One may say Ross Buckley is his area of research is financial stability, if I may say, in a very broad sense. Regulatory issues, of course, but the entire topic of international global financial stability is in the background of anything he's doing. He's well known for that. He's a professor at the University of New South Wales in Australia for several years already. He had been with other Australian universities before. Ross is advising governments, associations, NGOs and others globally. He is on several committees in this area. He has been a guest professor at foreign universities. He's known worldwide, and we're happy to have him here discussing this topic with us. I leave the floor to you. Anything that has to be said will certainly be said by you. Please, and thanks again for coming.
Thank you. Thank you very much for those kind words, Christian. Probably too kind or too generous. So this is the topic today. The starting point is that, to the best of my knowledge, in every financial system in the world has a bankruptcy regime. No nation tries to run a financial system without bankruptcy. And there's a very, very good reason for that. But we don't have a formal bankruptcy regime of any kind at the international level And what this really means is that when there's a lot of liquidity is in the rich countries, it flows into poor countries historically in amounts that are really too large. And then those capital flows end up being repaid at the expense of the basic human rights of people living in those countries. So today we're talking about a sovereign insolvency regime, and it's very timely because, as Christian hinted at, 2 months ago the UN General Assembly passed a resolution to begin negotiations on a global sovereign bankruptcy treaty. And 124 nations voted in favour of to commence these negotiations, which was basically every developing country. 41 nations abstained, which were most of the European countries, and 11 nations voted against. Have a guess. Who do you think voted against a global sovereign bankruptcy treaty? Take a wild guess. Any guess? The US, absolutely. Assume that the position I'm coming from today is that a global sovereign bankruptcy treaty is a really good idea. So if you accept it's a really good idea, which countries do you think would be opposed? Of course America, but Britain, France, Luxembourg, Switzerland, sadly Germany, sadly Australia, Canada, etc. But basically the money centre, most of the nations that have major financial centres. And we'll discuss later why they might have voted against it. But the impetus for it in the United Nations was this case, NML against Argentina. And I've subtitled it A Tale of US Courts Being, well, American. Right? This case is very much an American story. I can't really imagine quite the same thing anywhere else. But Walter Wriston in the 70s said countries never go bankrupt. That one pronouncement led to more loans being made to Latin America and Africa than any decision of any credit committee. He was formally right. He said infrastructure doesn't go away, productivity of people don't go away, natural resources don't go away. And so a nation's asset always exceeds its liabilities, so it's not bankrupt. This is the confident pronouncement of somebody who's never left the northeast of America in their life. Because of course in the 1980s in Latin America the infrastructure absolutely didn't go away, it crumbled because the governments had no money to fund it. AIDS sweeps through Africa and the productivity of the people absolutely goes away. You know, half of your middle class, your educated class are sick with HIV/AIDS, etc. And so as a substantive matter, he was spectacularly wrong. But as a legal matter, of course, he was technically right. Because for a country to go bankrupt means you have to, what do you need for bankruptcy? Bankruptcy is not a natural state. Right? The natural state is being broke. You know, most of the students here are probably in that state. Right? But you're not bankrupt, you're just poor. Right? What does it take you to go from being broke to being bankrupt? No, that's just being broke.
Court decision.
A court decision, yes. You need some set of rules, and you need some organisation to apply the rules. And to make a pronouncement, you declare bankruptcy, there has to be some sort of procedure. And that's what's missing. Because for a nation to go bankrupt, obviously the court needs to sit above the nation to determine the issue. And the only courts we have above the national level don't deal with these sorts of issues. So we're missing in my view, we're missing a critical piece of infrastructure in the global financial system. And it's really important to understand why we're missing it. The reason we're missing it is when in 1943 and 44, when John Maynard Keynes and Harry Dexter White put together the post-war economic architecture, they developed the architecture of the World Bank, the International Monetary Fund, what was supposed to be the International Trade Organization, which only became the GATT. This was all constructed to promote international trade, but their intention was to keep finance national. They never intended there be an international financial system. They intended there'd be big capital controls between countries and relatively limited movement of capital between countries. And they did that very consciously because of the global experiences in the 50 years leading up to 1929. That's what shaped their thinking. So they thought international trade is an unalloyed good. It's always to everybody's advantage. International finance is a much more dangerous thing to try to deal with. And so that, I'm sure, if White and Keynes had intended the globalised financial system we have, they would have given us a global bankruptcy regime, they would have given us a global financial regulator, and they would have given us a global lender of last resort. Because every national system requires those three institutions. I don't know of one country that doesn't have a lender of last resort. Now, a lender of last resort is typically the central bank, and its function is to pump liquidity into a financial system in large amounts really quickly to assure people that the banks are safe, to prevent a run on the banks. Banking is one of the most unstable businesses. I don't know if you have in German, do you have a saying as safe as a bank? In English, we have a saying as safe as the bank, right? It's either ironical or it's stupid. Because once you really understand banking, especially modern form banking, is really highly risky. Right? Australia's banks at the moment are amongst the most profitable in the world, and experts suggest a typical Australian bank, if investors became worried, could survive 3 days. 3 days is sort of the limit you have for the central bank to bail it out, or it's gone. You know, the run on the people will all pull their money out of the bank, and banks have very, very little capital. They are, of all the corporations, all of your big industrial corporations, you know, Mercedes, Siemens, all those, will have very large amounts of capital compared to Deutsche Bank. I haven't looked, but I can guarantee it, because that's how the world works. Big corporations tend to run on large amounts of capital. Banks, which you would think intuitively would have lots of capital, actually have very little, because they're greedy, because they like to make as much money off the capital they have. Am I speaking too quickly? Is it okay? You can understand? Can you deal with the accent? I know it's quaint, but okay. So, NML in Argentina. I've said a story of vulture funds, rapacity, greed, and judicial narrow-mindedness. So I'll talk a bit about it. The background to this, as Christian suggested, was that Argentina restructured its debt in about 2003, 2004. It went through perhaps the worst peacetime economic crisis in history. It was interesting because during the 1990s, Argentina was hailed by the International Monetary Fund as the poster child for how to restructure your economy. So Argentina did a very profound reform of its banking system. It did lots of things, and the IMF was holding it up to other developing countries, saying this is the example of how you should do this stuff. But with the IMF's agreement, what Argentina had done was pegged the peso to the US dollar. So it had passed a law that guaranteed 1 peso equaled $1 US, which stopped hyperinflation in its tracks, which has always been a problem. And it would have worked well if they'd unwound it after about 3 years. But the politics were complex, they didn't unwind it. And ultimately, if you are a nation and you tie your currency to the dollar, for your currency, which is now effectively the dollar, not to become overvalued, your economy has to perform as well as America's. Your economy actually has to outperform America's because America has all these wonderful capital inflows, right? It's the global currency, right? The US dollar is the global currency, so lots of investors want to invest in the US who don't want to invest in Argentina. That supports the value of the dollar. So if you're going to tie your economy to that of America's, you've got to have a very vibrant economy. Argentina didn't. It's sort of economics 101. Nobody told them. And at the end of a decade of having parity with the dollar, they had 45% unemployment, they were a complete mess, and eventually the government had to close the banks to avoid capital flight. I mean, Argentina went through, I think, 4 presidents in 2 weeks. What would happen? The president resigned, he said, I can't deal with this. The new president said, oh, I'll have a go, I'm good, I'm clever. He sat down, Treasury officials briefed him for 2 or 3 days, he thought about it, he went to sleep, thought, gee, this is good, what am I going to do? The next morning he stood up and said, I resign. Then the next fellow came, had a go for 3 or 4 days, he resigned. It was a truly intractable problem. So after Argentina held its ground, though, it insisted on a major discount with the banks, and there was a negotiated restructuring, and Argentina got the largest discount in history, effectively about 65%. So about 2/3 of Argentina's debt to commercial banks was made to go away. But only 96% roughly of the creditors signed up to that deal. 4% didn't. And as Christian rightly said, there wasn't collective action clauses in the debt, which meant that the people who didn't sign up a collective action clause would have said that what more than 3/4 of the holders of the debt voted for would bind everybody. That's what a collective action clause does. That would be in this debt if it was issued now, but it wasn't in this debt when it was originally issued, which meant that the 4% were entitled to full repayment. It's just a contract like any other contract. But of course, Argentina, as part of the restructuring, said if you don't agree to the restructuring, we are never going to pay you. And we are always going to pay the people who take the discount. So some of those banks who held out then sold their debt to the so-called vulture funds, hedge funds. And having done so, they sold it, I think, Argentina thinks it was about 12 or 14 cents on the dollar. So somebody bought, $100 face value of Argentine bonds for about $12. And then they instantly started suing Argentina in courts all around the world trying to recover this money. They even seized an Argentine naval vessel in a Ghanaian port in West Africa and tried to sell the vessel to recover the debts. The court wasn't very impressed with that. That was a dumb thing to do. I mean, there may be an exception for sovereign immunity for commercial activity, but how can you characterise a naval vessel as commercial activity? Anyway, they've tried everything. And mostly they've lost until they got to Judge Greaser, who is a grumpy old man, 84 years of age, in America, right? And he found in favour of the hedge fund, because he took the view, understandably I suppose, that, well, this is just a debt, and Argentina has the money to pay it, and the bond says it's payable. Argentina has plenty of money today, so it should pay it. And most experts in the field, at least on Wall Street, thought, yes, he's decided that, but the Court of Appeal will fix it, because that's what courts of appeal do. But the Court of Appeal didn't. Then Argentina appealed to the High Court. Argentina was getting desperate, to the Supreme Court rather. They were getting desperate by the time they appealed to the Supreme Court because they cited me. And if you cite one of my publications, you're guaranteed to lose, which is what happened, right? They were truly getting desperate. But I've just lost my train of thought. But the problem, I think, what the court failed to appreciate is that the law is New York law. Because if you're a developing country, your bonds are traditionally governed by either English law or New York law. If you're a developed country, the tradition is the bonds are governed by your own law, which, to take a little sidestep, is the real reason the Greek bailout worked out the way it did. Right? The Greek bonds were governed by Greek law. So ultimately, Greece could have made the debt go away. Could have just passed an act saying, well, all those bonds that are issued mostly to German and French banks, we've never liked the French. We've certainly never liked the Germans. Let's just make it just disappears. Wipe it out. Argentina didn't have that choice. The argument that needed to have been made to Judge Greaser was that we're using New York law here because it's the only available law. There isn't a sovereign lending law, which is what the UNCTAD principles that are being developed are trying to do, I think. I think they're trying to complement contract law to make it more contextually responsive for sovereign lending. The two big differences in the sovereign context is three, really. One is you can't levy execution if you're the creditor. You know that if you're lending to Argentina, it doesn't have any assets outside Argentina, except funds on account in banks that it is going to pull back the minute it's in trouble. So it's not like a normal corporate loan, where you can go and seize the assets of the company and sell them to get judgment. Most countries, have very few assets outside their borders. So that's a huge difference. The second thing that's a huge difference is there isn't a bankruptcy regime. So if the debtor gets into trouble, there's no regime to allocate losses between the debtor and the creditor. And the third massive difference is if you are not completely stupid, you know that Argentina defaults on its debts regularly. Right? It's just what it does. Open any history book. Right? 1828, 1878, 1930, 1982. Every time Argentina defaults, it's just the politics of Latin America. It overextends itself. So this argument needed, I don't know whether it was made or not, but if it was made, it wasn't accepted. So the judge just applied the law in its purity. We've just had a very similar case in Sydney about 3 weeks ago. Nauru is a desperately poor little island state in the Pacific. It's so poor it doesn't have a bank branch. Westpac used to have a branch there, but it's closed now. So imagine living in a country without a branch. You can't get money out, you can't put money in. You know, this is a very, very poor place. But it had a debt that it owed to Japan, and it wasn't bonds, but it was a debt for some commercial arrangement. And some Australian bought it for about 8 cents on the dollar, right? So whatever that is, $80,000 for $1 million worth of debt. And then he sued in the Supreme Court of New South Wales to recover the debt. It was much more than $1 million, it was 100 million or something like that. And the judge was faced with the same problem that Judge Greaser was faced with. It's a commercial debt, it arose in business, it's completely normal, it's been sold to somebody, which is also completely normal, and Australian courts enforce those debts every day of the week. This judge, I know him very well, personally. He's another grumpy old man. He's particularly rude and unpleasant as a human being. At least he's been rude to me on many occasions. But he found a technical reason to find against the vulture in our case. He found a very technical reason about how process had been served, and he said process was not, the papers that initiated action were not properly served on Nauru. I don't know, sounds surprising. Sounds like the easiest thing it would be in the world to serve legal process on a nation, but he found some technical reason. Because clearly, he did not want, this country is one of the 5 poorest in the world. He didn't want to enrich some Australian investor who, by giving him 12 times as much, a return of 1,200% on his investment, just because he's bought the debt and he's getting 100 cents on the dollar. I don't know whether the decision is final, so that case may come back in Australia. But anyway. So, this case is why we had the resolution in the United Nations. Argentina pushed very hard for it. I spoke last night in Berlin to the Argentine Consul General in Germany, and he said Argentina, frankly, expected Australia to vote against, expected Germany to vote against, so we didn't upset them. But Ireland voted against, and he said that broke, he's very Argentine, he said it broke our heart. He said it broke our heart to think that Ireland, which has had all these financial troubles, would vote against us. We still, it's almost like an opera. We still can't, understand it. So if it's any consolation, he thought you guys would be tough, okay? You haven't upset him that you voted against it. But, so what, if we had sovereign bankruptcy, what would it look like? Well, it wouldn't look like personal bankruptcy. It wouldn't look like corporate insolvency. For the reasons I've hinted at, most of the things, by the way, if you don't understand or you've got questions, just wave your hand, right? I like waving hands, I'll answer any. Don't throw things. I have an objection if you throw things. And my students often throw things in lectures at home, but just wave your hands, that's fine. What it basically would amount to is a decision that cancels a certain proportion of the debt. There's not a whole lot else that can be done, right? You have a country that has borrowed a certain amount. A court or an arbitral tribunal would have to apply a set of rules to determine how much debt the country can continue to service without compromising the very fundamental rights of its people, and how much debt should be wiped out. And basically, any sort of sovereign bankruptcy procedure would be a bundle of rules aimed at achieving that outcome. The difference from what we have at the moment is an ad hoc informal system that basically produces the same result, a degree of discount. Usually, before Argentina, the discount was about 35–40%. Lee Buckley is the doyen of sovereign debt lawyers, and he's also a very, very funny man. He's a partner in a Wall Street firm, and he always says, each sovereign restructuring is negotiated on an entirely individual basis. Each country gets, Cleary Gottlieb's full attention and completely individual treatment, and after 4 years, each country gets 35% discount. Doesn't for the last 25 countries. So the differences to what we have at the moment, it should be a quicker process. What we have at the moment is very slow because it's negotiated. Civil society likes the idea because they think the amount of debt that would be cancelled will be higher, but I don't know that there's any evidence for that. That's just what civil society organisations hope for. And it would be a rules-based process determined by an independent forum, not just a negotiation in which the bargaining power of the parties is rather unequal. So this is the background. I won't go into this too much. In a sense, if you're interested in debt crises and these problems, they began in 1982 with the collapse in 1982. And the background to that was that with the OPEC oil price rise in 73 and again in about 78 or something, the rich nations of the world had a choice. All of a sudden, oil became 4 times more expensive. So what Germany could have done is it could have cut its living standards to afford the oil. Or it could export more money, export more goods, earn more money, and therefore use that money to pay for the oil. So the German government, like the French government, the American government, all chose the latter. Right? If you're faced with higher costs, it's like you individually. Suddenly your rent doubles, you can earn more or you can spend less. Earning more looks more attractive than spending less. So the rich country governments encourage their banks strongly to lend a whole lot more money to the global south, so that those countries could increase imports from the rich countries, and it worked very well for quite a while, until those countries in Africa and Latin America suddenly had too much debt. And in August 1982, Mexico basically came along to America and pulled its pockets out and said, we're bankrupt. And America did a very good deal for Mexico overnight because Mexico is important to America. So we've had a succession of those sorts of crises. As I say, there's sort of nothing new about them. 1982, 1997 in East Asia, 2002 in Argentina, Greece in 2011. We've had Turkey and Ireland and Iceland and Cyprus, and they're becoming more and more common. They're becoming more and more common because our financial system started to globalise in the 1970s and 1980s. In the early 1970s, America couldn't afford the Vietnam War. Just as Argentina defaults, America regularly goes to war and doesn't have a way to fund it. Right? And in the 60s it was Vietnam. They couldn't really afford it. They therefore took the US dollar off the gold standard, which had been the basis of the post-war architecture, and all of a sudden the systems of capital controls around the world started to get dismantled and a financial system globalised. To the point that today, finance is as globalised as anything. Markets for oil, wheat, soybeans, money, they're all the most globalised markets in the world. And the problem is that we don't have a regulatory infrastructure that's up to the task, as far as I can see. It's interesting, if you look at personal bankruptcy, they're the purposes, to divide the assets between creditors and allow the individual to make a fresh start. We don't imprison individuals for debt anymore. We haven't done it for hundreds of years. So Roy Good, one of my academic heroes from the UK, says that there's 4 reasons we have a corporate insolvency law. To restore companies to profitable trading, to give reasonable returns to creditors, to rank claims and distribute losses, and impose sanctions for bad management. At the time I put this together, which was some years ago, I went through all of the textbooks, and everybody says, at least in my tradition, I don't know about civil law, but in the Anglo-Australian tradition, all of the authors are on the same page. These are the reasons we have insolvency laws. What nobody mentioned, which you see really clearly in the international context, is what I call the credit allocation effect of insolvency law, or the systemic effect. And that is that if you have an insolvency law, it makes creditors think carefully. The only thing bankers hate more than death itself is losing money. So if there's a legal procedure which says this entity is bankrupt and the creditors have to lose that amount of money, that will modify how much money the banks lend to that entity. At the domestic level, at least in my legal tradition, nobody seems to think about that. But you see it very starkly. So I think if we had a bankruptcy regime, one of the things it would do is make credit more expensive for poor countries. Because I actually think that would be a good thing, because at the moment, very clearly the real risks of international loans are not factored into their prices. When there's a lot of liquidity in the developed markets, loans go out to poor countries at very cheap rates. And you saw that classically in the lead up to Greece's crisis. Greece was borrowing money at rates that were really far more appropriate for Germany than Greece. Greece has never been that good a credit risk in its life. But markets are very bad at pricing that, particularly when there's no bankruptcy regime. They just assume the government will not want to default and will just keep servicing the debt long past the point where it would be reasonable to default. And history says they're right to do that. Governments hate defaulting. So they'll generally keep servicing foreign loans at the expense of their people. Why do we not have one? Why don't we have, if a global bankruptcy regime is a good idea, Adam Smith in 1776, when he wrote The Wealth of Nations, said it was a good idea. It's not a new idea. He said we needed one then. Well, I think there's 5 reasons we don't have one. One is before 1980, we didn't need one so much. The system wasn't globalised. Sure, we had a major, debt problem somewhere in the world, but it happened about every 50 years. Now it happens about every 2 or 3 years. So now if we had a global sovereign bankruptcy court, it would be quite busy. It's very hard to create international institutions. Look at the International Criminal Court in The Hague. It took 56 years after the war to create that. The idea was straight after the war. Or most international treaties typically take a number of decades before they get enough signatories to be implemented. The last 2 are also really important reasons. I say the perceived interests of creditors hate it, and that's why the 11 nations voted against it, because they are the home of most of the creditor banks. I say the perceived interests of the creditors because after the 1982 crisis, that was partly resolved by those loans being converted into bonds, Brady bonds they were called, and after Nicholas Brady, the Secretary of the US Treasury. And the banks around the world hated that idea. And yet it's very clear with the benefit of hindsight, the Brady bonds were a very good deal for the banks generally. They were much better off with these renegotiated bonds that were designed to be traded, that they could easily sell, they could pass the risk on to somebody else. They were much better off with those bonds than they had been with the loans. But they only eventually agreed because their central banks put so much pressure on them. And ultimately, if you're a commercial bank, you operate largely at the whim of your centre. If you're a German bank and you get the Bundesbank sufficiently far offside, they can make your life miserable for a long time. So you just won't do that. And the other reason we don't have one is the short-term interests of debtors. When the IMF proposed something, not quite a sovereign bankruptcy regime, it was called the Sovereign Debt Restructuring Mechanism in about 2003. It was the idea of an Australian, Ian Kruger, who was deputy at the IMF at the time. Argentina voted against it. And it voted against it because it knew that any such mechanism would probably make credit more expensive, and poor countries like borrowing as cheaply as they can. There was a time for years the World Bank tried very hard to get developing countries to borrow in their own currencies and to develop secondary markets in loans in, Indonesian currency or Thai currency or Greek drachma when they existed or whatever. It never succeeded because the countries never really wanted to borrow in their own currency. They wanted to borrow in dollars or euro because it's cheaper. But they'd actually be much better off borrowing in their own currency because it has a big insurance element. If they get into financial trouble, the loan becomes a bit easier to repay. If you get into financial trouble and you've borrowed in a foreign currency, the loan quickly becomes almost impossible to repay. I won't go for too much longer. How would we do it if we were going to do it? My argument is Chapter 9 of the US Bankruptcy Code, which deals with local governments, municipal governments in the US. So governments the level below the states. They have gone into bankruptcy quite often. This has been around since 1934. There's now been 654 proceedings, I'm assured. Most of them are not actually local governments. They're local authorities set up for a purpose, like some authority set up to run a dam or run power generation or something like that. But there's still government entities that go bankrupt. And Kenneth Rogoff, who's an excellent economist, has looked at this in detail. He's given it a big tick. As a system, it works pretty well. And it deals with the same sort of issues you'd have to deal with a sovereign. For example, there's whole procedures. There's a definition of insolvency. There's a procedure for objections. There's procedures for the creditors to prove what money they're owed. And there's this section 904, which says a court may not interfere with any of the political, governmental powers of the debtor, can't interfere with any of the property or revenue of the debtor, and it can't interfere with the debtor's use of income-producing property. And the reason that is in there is in America, local government mostly runs the school system. So the high schools and the primary schools are owned by the local authority, right? It's a disastrously stupid way to run a country because what it guarantees is the perpetuation of inequality. right? If you have a very rich neighbourhood, it will produce fabulous public schools because they have very high property taxes on the homes, and all those resources go into very good public schools. And if you have a very poor neighbourhood, you are going to perpetuate, disadvantage. But it's the American system. So you can't have creditors coming in and seizing the public schools to exercise execution and recover their money. The same way you can't have creditors, deciding to buy, parts of Argentina, or take parts of Argentina. We'll take Patagonia in the south because you owe us money. I mean, I don't know. Was Germany serious about taking some Greek islands in the Greek default? It certainly got a lot of publicity in the Australian press. It sort of appealed to Australians, the idea that Germany would just go down and take, Samos and Rhodes and a few others. They're filled with Germans between July and October anyway, I think, so you may as well sort of own them. But anyway, if we did it, if we actually did it, what would be the advantage? I think the procedure would be more rapid. I don't think the IMF, if you have the current situation, you typically have the IMF in your finance ministry for a number of years, telling you what to do, how to run your country. And the IMF's track record on that is not very good. So you pay if you're a debtor country and you have the IMF setting policy, you lose control over your own policy, and the effect is certainly not good for the poor people in your nation. It may not be too bad for the elite, given the set of policies. It would certainly change the amount of lending and the amount of borrowing. And it would, I think, if you had an insolvency regime, creditors would be more careful about borrowing, and so would the debtors. And it's really interesting. I did a session last night in Berlin with a whole bunch of economists. There was a very bright young economist there, and he kept banging on about irresponsible borrowing. Right? On and on, irresponsible borrowing. There's too much irresponsible borrowing. And when it came time for the panel discussion, I pointed out to him that that's the language you always hear. You always hear irresponsible borrowing, but not irresponsible lending. But I said, debt is like pregnancy. You can't get into it yourself. You need both sides. But the banks only ever talk about irresponsible borrowing. But the system would be more stable because capital would flow more carefully. And this idea of moral hazard is in a financial context when a financial actor doesn't bear responsibility for their actions. So creditor moral hazard would be greatly reduced. At the moment, in loans to poor countries, the creditors keep lending because they know pretty much the country's going to keep servicing it. They'll keep lending past what is reasonable because they expect they'll keep getting paid. Debtor moral hazard, this is what people worry about. People worry about if you had a formal regime, countries would rush to it and declare bankruptcy all the time. But history just tells you that doesn't happen. Even the IMF itself says that countries are far too slow to default. Horst Kohler, I assume he's German, with a name like Horst Kohler, he must have been German. He says, right, that countries are far too slow to default. And the IMF has got a difficult situation. When you have a country that has too much debt, the IMF doesn't have enough policy options at the moment. It can keep lending. That's not really helpful because the country's got too much debt. Right? So it's just pouring more petrol on the fire. Or it can cut off lending, which is going to trigger a default and a collapse. And it's got nowhere else to go. It either keeps lending or it stops. So it proposed this debt restructuring mechanism to give it another tool to work with, but it didn't go anywhere. Collective action clauses, I mentioned before, they're part of the solution, but they're not the entire solution. They stop the free rider problem. They stop, if we'd had collective action clauses when the Argentine debt was restructured, NML capital would have been bound by the decision of the majority. But that's all it does. It doesn't help the core problem, which is if you have a country that is heavily over-indebted and it can't service its debt. It doesn't help that country. And to give you an example, I mean, between about 12 years ago and 5 years ago, the Philippines spent 2/3 of its annual federal budget on debt service. So it had 1/3 of the money that the government raised from taxes to do unimportant things like educate Filipino children, run hospitals for Filipino people, build roads, everything else. And 2/3 of its income went on debt service. Even in that situation, the Philippines didn't default. did the opposite. It passed a law, doubly entrenched law, that said it wasn't allowed to default. So there's very little chance that countries are going to default without excellent reasons. So in conclusion, history tells us nations don't usually default. They just keep servicing their debt. They can always do this because they can keep raising taxes and they can keep reducing services. But in a rich country like yours or mine, increasing taxes and reducing services doesn't involve human rights abuses. In poor countries, it involves severe human rights abuses. National bankruptcy regimes ensure that the creditors get the maximum amount without throwing debtors into absolute desperate poverty, without stopping them having food or housing. And we rejected debtors' prisons centuries ago, but at least in the rich commercial bank lending to very poor country situation, we still have something very much like debtors' prisons. Loans that were made to Argentina in, say, 1978 will be repaid in something like 2025. That's an awfully long time, 47 years or something. That was a 5-year loan made in 1978 that got rescheduled and then rescheduled and then rescheduled again and converted into 30-year Brady bonds, and it will finally be repaid 45 years after it was made. That's an awful lot of interest to pay on a loan, and it really does amount to something like debtors' prisons. So on that note, I will end, and over to you. Questions, please.
Wir haben hier Spitzenausbildungsbedingungen, eine tolle Uni, kompetente Dozenten und eine praxisnahe Ausbildung. Hier kann es jeder schaffen, wenn er will. Doch am Ende liegt es in deiner Hand.